Welcome to this explainer. Today, we are setting the stage for a really deep dive into one of the most monumental challenges of the modern era, South Africa's transition to a non-racial democracy. It's an incredible story of profound change, but as you might guess, it's also a story of immense legal complexity. Specifically, we're going to unpack a fascinating 1998 constitutional court case, the African National Congress and Jacob Zuma versus the Minister of Local Government for KwaZulu-Natal. Honestly, this case is an absolute masterclass in constitutional law. It shows us exactly how a country goes about rewiring its entire system of local government without, well, causing the whole structure to just completely collapse.
Okay, let's dive right into our legal docket for today. We'll start with tradition meets new democracy, then examine the constitutional compromise. After that, we'll break down the two-part legal challenge, review the court's final judgment, and finish up with a victory on court costs.
Section 1. Tradition meets new democracy.
To really understand this case, we have to grasp the sheer scale of the problem back in 1994. Rebuilding local government meant they had to merge elected urban councils with rural areas that were traditionally run by chiefs. The stakes here were incredibly high. In fact, the Constitutional Court literally noted that the country had to be urgently rescued from imminent disaster by a negotiated commitment. You couldn't just erase traditional leaders with the stroke of a pen. A compromise was absolutely essential to avoid total disruption in those rural areas.
And this brilliantly illustrates how they mapped it out. To manage this massive shift, the government used a very specific timeline under the Local Government Transition Act, broken down into three distinct phases. The pre-interim phase kicked off in February 1994, even before the interim constitution took effect, leading right up to the first democratic local elections. Then came the interim phase, which started after those first elections in 95 and 96. Finally, a final phase was penciled in for a future date. This messy legal battle we're looking at today, it places us squarely in that tricky transitional interim phase.
Section 2. The Constitutional Compromise.
So, to make sure this handover of power was actually smooth, the drafters created a specific rulebook to bridge the gap between traditional authority and these newly elected local councils. That mechanism was Section 182 of the Interim Constitution. It basically guaranteed that a traditional leader living within an elected local government area got a seat at the table. No democratic elections required. Their historical status essentially guaranteed them a voice to help ease the transition.
So the crucial point here is this specific legal term, ex officio. It's a Latin term that literally means by right of office. Think of it like getting a position on a council simply because of the status or office you already hold. The entire lawsuit we're examining hinges on this exact concept. Whether traditional leaders in the province of KwaZulu-Natal had the constitutional right to sit on newly formed regional councils just because of who they are.
Section 3. The two-part legal challenge.
Now we get to the high-profile lawsuit brought by the ANC and Jacob Zuma against the KwaZulu-Natal Minister of Local Government. And hey, just a quick reminder as we go through this, we are looking strictly at the mechanics of the law here, impartially analyzing the text without taking any political sides. At the heart of this dispute was Proclamation 54 of 1996, which established 7 regional councils for the province and stated that traditional leaders would sit on them as ex officio members. The appellants wanted to completely invalidate this proclamation, arguing that giving traditional leaders these specific seats violated the strict letter of the interim constitution.
To do this, the appellants launched a super technical two-pronged attack. First, they argued that these new regional councils did not technically qualify as Chapter 10 local governments under the Constitution. Second, they argued that because the councils included some members who were nominated rather than voted in, they couldn't legally be called elected local governments. If either of those arguments held up in court, traditional leaders would have zero constitutional right to sit on these councils.
Section 4. The court's final judgment. Now, what's really interesting here is how Judge O'Regan, speaking for a unanimous constitutional court, meticulously dismantled this lawsuit step by step. Let's look at that first argument about Chapter 10. The appellants took a very strict reading, basically saying, hey, these councils rely on the Transition Act, so they aren't real Chapter 10 governments. But the court pushed back hard. They clarified that the Constitution explicitly stated local government restructuring had to be managed exclusively by the Transition Act during this phase. The act was literally just the vehicle used to build Chapter 10 governments.
Judge O'Regan actually pointed out, playfully but firmly, that the appellant's logic would lead to what the legal world calls absurd results. I mean, think about it. The entire purpose of Section 182 was to allow traditional leaders to help ease the super difficult transition.
If the appellants were right, traditional leaders wouldn't be allowed to sit on transitional councils at all, which completely defeats the law's entire purpose.
Next up, the court tackled the second argument, that the councils weren't truly elected. Now, it's true the Transition Act permitted provincial ministers to include some nominated members to represent specific interest groups, like farmers, women, or levy payers, but the law placed absolutely strict caps on this. No single interest group could exceed 10% of the council, and all nominated members combined could never, ever exceed 20%. The vast majority, at least 80%, had to be elected.
So let's just pause and think about that for a second. If a democratic body is set up with a small, strictly capped percentage of nominated members, just to ensure specific interest groups have a voice during a really fragile transition, does that magically transform the entire body into an unelected one? Well, the court's answer was a resounding no. Judge O'Regan ruled that in the context of the Constitution, the phrase elected local government didn't mean 100% purely elected without a single nominated member in sight. It simply meant local government operating in the phase after the first democratic elections had actually taken place. Since the regional councils in KwaZulu-Natal were overwhelmingly elected, they were completely valid, and that meant the traditional leaders rightfully kept their ex officio seats. The appellants lost on the merits.
Section 5. A victory on court costs.
Let's move to how this all wraps up with a really fascinating final twist regarding the legal bill. Usually, the loser has to pay the winner's legal fees, which is exactly what the lower court ordered the appellants to do at first. But the Constitutional Court actually reversed that. Why? Because in a thriving constitutional democracy, citizens shouldn't be financially punished for bringing complex, genuine, and broad public concerns before the highest court. Even though the appellants lost their case, it wasn't a frivolous lawsuit. They were asking vital questions about how power should be structured, so the court ordered that nobody had to pay the other side's costs.
And that brings us to the end of our explainer. This case from South Africa's transition is just a powerful reminder of how the law can be used as a flexible tool to bridge massive societal divides. So I want to leave you with this provocative final thought. How do we balance modern democratic ideals with deeply rooted historical traditions in our own evolving societies? Thank you so much for joining me today to explore this fascinating piece of legal history. If you enjoyed this, please check out more of our structured visual explainers. Keep learning, and I'll see you next time.